So this says, allows a victim to ask the court for an injunction against harassment at the time probation is terminated or community supervision or parole is granted. Okay? So, first of all, it's inapplicable because Shannon Walker is not a victim at this point. Okay? It goes on to say, the court may suspend a sentence of a person who is convicted of an offense is eligible for probation. The court may either on its own initiative or on the application of the probationer decide to terminate the probation or intensive probation early. The court must provide an opportunity for the prosecuting attorney and victim to be heard and may only end the period of probation if doing so advances its ends to justice and if the conduct of the probationer warrants it. Right? So that would mean you would have to let the person be on probation and see what his conduct is like to see if, one of these is warranted, right?
A probation officer. I'm also going to impose a lifetime injunction, get into a discussion because it's going to make it unclear. So if you have an issue with that, you can raise it with the probation officer. I'm also going to impose a lifetime injunction under 13-719A and CR 20251060, and this.
Okay, so he's going to impose a lifetime injunction under 1060, according to blah, 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 blah. At the time of sentencing, on request of the victim or the prosecutor, the court shall issue an injunction that prohibits the defendant from contacting the victim if the defendant is convicted of any of the following offenses, whether completed or preparatory. Okay, so what is a conviction? When do you get convicted if you don't have a jury trial? So I know most of you are going to be like, well, when he signs the plea agreement, right? Well, it said he signed it on June 9th, right? But the judge threw that out. She said there's no factual basis. You have not given a factual basis. It does not meet the whatever. And so, you know what I mean? We all heard her say that, right? But in the minute entries, it looks like this. And this is the PDF. I downloaded the PDF file, right? So it goes straight from this one that doesn't have a page number to only page 2 of June 9th, right? That's weird, right? That the PDF would do that? Why would the PDF do that? Well, because... And just so y'all know, a plea agreement is not a conviction. It can lead to a conviction, right? But it is not the same thing as a conviction. Now, we'll get into that later. But let's say that you're right and it is a conviction, right? So he would be convicted at the very moment he signed the plea agreement, right? So if he signed it before he gave the factual basis and it was rejected, then that would be a dismissal, basically. So here's the documentation that the judge thinks gives him the authority to do what he's doing, right? So this is the very bottom of that. An injunction that is issued pursuant to this section does not expire and is valid for the defendant's natural life unless any of the following occurs. The defendant makes a showing to the court that either the victim has died or the conviction has been dismissed, expunged, or overturned, or the defendant has been pardoned. You could say that her not accepting his conviction after he signed it, right, is it being dismissed, expunged, or overturned. You know what I'm saying? But they only showed the second half of that minute entry. Why did they do that, right? And if you agree with that, so look at here. It says that it is ordered setting the matters for judgment of guilt and sentencing on July 1st. So, technically, he's not going to be sentenced until July 1st, right? Even though he's already signed an agreement and it's been basically dismissed by the judge. So why the hell is this part missing where he gave the factual basis and they didn't accept it right here? Why is that missing? Here's a picture I took of my TV whenever I saw this for the first time. It clearly says... The court finds there is no factual basis for the plea agreement. How can they find a factual basis and accept it if there's no factual basis for the plea agreement? Huh?
Files has prepared that. And I sign it. Does the defendant have to sign it as well? Yeah. So, no, just,
Yes, there needs to be a receipt of service.
Just on the service one.
okay, prepared that. And I sign it. Does the defendant have to sign it as well? Yeah. So, no, just,
Yes, there needs to be a receipt of service.
Just on the service one.
okay. So, Mr. Myers, I'm imposing the lifetime injunction as a condition of probation. I'm ordering you to accept service of that. And you'll have to sign that as well. All right. So the court imposes the following assessments. In CR 2025-1060, the court imposes a time payment fee of $20, probation fee $65, probation surcharge probation surcharge $20, additional assessment $13, victim right enforcement assessment $2, victim right assessment $9, and CR 2025-1454, time payment fee of $20, probation fee $65 concurrent, that means one payment for both cases, probation surcharge $20, additional assessment $13, victim right enforcement assessment $2, victim right assessment $9. You do have the right to file a petition for post-conviction relief within 90 days of today's date. If you can...
Okay, he just said it. You can file a post-conviction relief in 90 days of today's date. So that date, July 1st or whatever, is when he was convicted, right? So how could any of that, before that, how could you be a victim? Nowhere in the probation thing does it say anything about lifetime injunctions being part of probation or being ordered by the judge as a condition of probation. I'll post that here, or I'll put it up here in a minute because it's long as shit, but it doesn't say it anywhere. All right. But here's the other thing that I have an issue with. All right. So if they're accepting his June 9th thing, or his, whatever, even though the judge rejected it, but they're accepting that as him signing for his conviction, right? So as of June 9th, he's convicted, right? Apparently, right? So this says if he is, the allegation that the defendant committed a violent crime and at the time before the date the case is actually tried, right? Unless the allegation is filed fewer than 20 days before the case is actually tried and the court finds whatever, right? Well, the actual trying of the case would be his conviction, right? Because there was no trial. So signing of the document on June 9th would be the case being tried, right? So how do they allow this on June 4th? Notice of intent, prior convictions, and how do you invoke victims' rights before she becomes a victim? This is 5 days before his guilty plea or whatever. You know what I'm saying? How do you do that? How is that possible? This is straight bullshit. So the state's notice of intent to bring up prior convictions happens on 6/4, right? And then his so-called trial date is June 9th, right? Because that's when he signed his conviction thing. So that's 5 days, right? That's not 20 days apart. You know what I'm saying? And even if you had the sentencing, like what they did is they took June 9th and look, July 1st, that's like almost exactly 20 days. You know what I'm saying? But again, he said that it's sentencing and the conviction. If you look at the minute entry, so dude, this is all jumblefuck, dude. These guys are fucking crazy. And you know how I think they're getting away with it, or think they're getting away with it? It's because of this. This shows a knowing and intentional intent and a knowing intent to fuck Mr. Myers, because bringing up victims' rights and invoking those rights before she becomes a victim, before there's a trial, before there's a conviction, is an allegation of a crime. Right? So they can't bring up victims' rights and invoke them if she's not a victim of any crime yet. That is an allegation. And the fact that they waited 20 days until sentencing / other conviction / other whatever just shows that they're aware of this and that they try to fucking avoid it. You know what I mean? It's ridiculous, dude. These people are crazy. Anybody who's not paying attention, well, here you go. Now you're paid attention. But the reason they think they can do this is for this right here. How can you have two of these fuckers open. And, dude, it's just so they can put the minute entries and take the ones they want, get rid of the ones they don't, you know what I mean, add it up real nice, and then fucking just forget about the one that's not, you know what I'm saying? It's ridiculous, dude. How could they do this? Like, this is ridiculous. And they're the exact same. Lane Jeffrey Myers doesn't even have an alias or nothing. Exact same, just duplicated. That should be illegal right there.
Probation or receive an absolute discharge from prison for this offense, and if you've not been previously convicted of a felony and paid restitution, your civil rights will automatically be restored. If you've been previously convicted of a felony offense in this or another state or not pay all ordered restitution, you can still apply to have your civil rights restored. This is not applied for restoration of firearm rights if you are convicted of a dangerous offense or serious offense. You have the right to file a petition to set aside the judgment upon completion of your sentence, and the right to file a petition on 13-911 to seal your case records. In addition to signing the order of protection, you'll have to sign both probation forms to receive probation. I'm going to order you that you...
So he's ordering him to sign the order of protection forms to receive probation, yet as a condition of probation, he is allowed to impose these orders of protection for life. Think about that. That is fucking ridiculous, dude. Like, dude, this is a clown show, bro. I don't care what y'all say. This is clown fucking, dude. This is clown college, baby.
Be released to Pima County Jail today.
Okay, so here we go.
Sign that
September 12th, F5 felony. September 12th, F5 felony. F3 felony. September 12th, misdemeanor. And this is my absolute favorite. There being no factual basis for the plea, right? But then the state provides the factual basis for which the defendant concurs. No, I think he didn't concur then or in the very first injunction against harassment. In fact, I think he said the exact opposite, that there is no factual basis for him encouraging his followers or subscribers to do anything.
And then he would put it onto his YouTube page, and then he put it up there, and he would encourage his followers to contact her, in which they did, and they left her harassing messages that also range from things like wanting her to be raped and killed. And so these messages kept coming in. He was made aware of these messages. He's indicated numerous times that he was aware that his followers were reading these type of messages, and yet he continued to put up her information during this time and causing those followers to continue that contact with her. So he had initial contacts with her where he left her that message. He went to the law school looking for her, but then he also would use his social media to encourage followers to continue that contact.
Do you understand that all of that would have made her fear for her safety, Mr. Meyer? Okay. Then do you have any other reason why she would fear for her safety?
Because she doesn't understand that she's took an oath under ARS 231.
Taking an oath doesn't mean you have a right to be harassed,
I didn't harass her.
great fear.
It's an allegation other people did, not me.
So, but sir, if you're promoting them and
I
encouraging
promote
them.
anybody and I didn't encourage them. There's no factual basis for me
I don't-
encouraging them.
Okay, thank you, Mr. Meyer. At this point, I can't take your plea because I have a factual basis, and part of that is that Shannon Walker to reasonably feel for her safety or the safety of her family. And if you can't, and I'm fine with that if you can't do it, so you know.
But I'm just curious if you're asking me to admit to that because the state even just said that other people know it.
And that you were aware and you continue to post for address and information and you continue to encourage people.
Okay, that he was aware and that he continued to encourage people, right? What do you mean? The only time that it's even been said is an allegation by the state.
Work number that was shared by Mr. Myers and that he encouraged people to reach out to me at.
And I was looking at something else, I apologize. Say that again?
They're all to my work number, and they happened immediately the same day after Mr. Myers live streamed and encouraged his followers to reach out to me.
Any objection? Of course, sir, that's mental gymnastics. There's no way to prove that these people called because of me, and you shouldn't be giving out people's numbers. She's so worried about all this. Why is this being put on a public record? These random people that we have no way of corroborating if they were calling on behalf of me.
What's the legal objection?
My legal objection to her?
To the admission of the exhibit.
We have no way of knowing that these had anything to do with me.
All right, the objection's overruled. Exhibit 9 is admitted. For Mr. Myers, I hear what you're saying there. That's something for me to decide based on the weight of the evidence. If I can.
I'm going to get to argue that right when it's my turn to go.
I mean, and this should tell you everything you need to know about Medcap and the prosecution is whenever they have a request to film a certain case or whatever, trial, whatever the hell it is, court function, that they're separate requests, and the facts and the fact pattern of the cases and the people in them are different enough to have two different case numbers. Yet whenever it comes down to a possible digital and audio recording of the two different cases that are so different that they need different case numbers, yet when it comes down to the findings of if they're allowed to film or not, then both of them can just be put on one of the case numbers. They're similar enough to not be considered different whenever it comes to the on the record findings of why they can't film it. But whenever it comes to the actual facts and whatever's of the cases, they're so different that they have to have two different case numbers. Think how retarded that is.
Probation or receive an absolute discharge from prison for this offense, and if you've not been previously convicted of a felony and paid restitution, your civil rights will automatically be restored. If you've been previously convicted of a felony offense in this or another state or not pay all ordered restitution, you can still apply to have your civil rights restored. This is not applied for the restoration of firearm rights if you are convicted of a dangerous offense or serious offense. You have the right to file a petition to set aside the judgment upon completion of your sentence, and the right to file a petition on 13-911 to seal your case records. In addition to signing the order of protection, you'll have to sign both probation forms to receive probation. I'm going to order you that you be released to the Pima County Jail today. Let me sign here. I'm going to sign that order.
Your Honor, may I approach?
Yes.
The order for the lifetime no contact
Okay.
protection has to be signed by the court. So we're gonna hand you all the documents.
Wonder what this little bullshit is all about. Maybe she's telling them, hey, we really can't do this, you know what I mean? But we're going to do it anyways. Fuck this guy.
All right. I'll also note he's he was served with a copy of the order today at sentencing, and he'll have to sign that. Signed by the victim.
Signed by the victim. Give me a break, dude. You mean requested by the potential victim? There's no victim.
Okay. So I'm going to hand that back to you, Ms. Stiles. You'll get Mr. Myers to sign that as soon as we're done here. All right. Ms. Stiles, anything else that I need to address?
I don't believe so.
And Mr. Myers, anything else I need to address? You'll have to make an appointment with probation. Tell me, he'll do that tomorrow, maybe?
Yes, Judge, he can do that tomorrow. There's just one thing I wanted to address on behalf of Mr. Myers.
Uh-huh.
Your last condition that I was able to write down was no posting about the victim or the victim's family? Is that?
Anyway, it's just a bunch of bullshit. But anyways, here's the probation thing. And some of y'all may be thinking this little part right here means that
Yes.
he can do what he did, but it doesn't, because it says the law requires and the court deems appropriate. The court deemed it appropriate, but the law doesn't require it because it's a request. It's a request. None of this even makes sense because a violent crime includes any criminal act that results in death or physical injury or criminal use of a deadly weapon or dangerous instrument. None of that happened. None of that happened. You guys are all clowns. You guys can all go to clown college and get your big shoes and noses. Doug Metcalf will have no problem issuing a lifetime injunction for clownery to anybody who wants to wear big shoes and a red nose as a condition of their probation, as authorized by probation, for probation, because of probation, as a part of probation. Shut up.